My name is Katerina Asanova, and I'm a senior trial counsel at the Office of Foreign Litigation at the U.S. Department of Justice. I am also one of this year's annual meeting committee members. I would like to welcome you to a Supreme Court mock oral argument, should courts grant discovery in aid of arbitration. This panel will be in a form of a mock oral argument with 3 justices and 2 advocates. With a cert petition pending before the Supreme Court in a clear circuit court split, the question of whether Section 1782 can be used by U.S. courts to provide aid in the form of compelling discovery for use in private international arbitration is both current, relevant, and could have a wide-ranging impact on foreign arbitration proceedings going forward. It is my distinct honor to introduce our distinguished panelists. Our Chief Justice is the Honorable Bernice B. Donald, who sits on the United States Court of Appeals for the Sixth Circuit. Joining Judge Donald as justices are Dr. Stacey Strong from the University of Sydney Faculty of Law and Professor Andrea Wang from the University of Pennsylvania Law School. Representing the petitioner will be Ms. Yasmin Lalou, a partner at Chaffetz Lindsay LLP, and representing the respondent will be Mr. Alexander Blumrosen, founding partner of Polaris Law. We will start the 20-minute argument for the petitioner, followed by 20 minutes for the respondent, with a rebuttal and rebuttal. I would also kindly like to remind you to stay with us for a continuing the conversation discussion that will take place immediately after the panel, where you will have a chance to engage with our panelists and ask questions. Thank you to ASIL and our esteemed panelists for what will surely be a lively and interesting debate. And with that, I would like to turn it over to Chief Justice Donald.
Good morning. The panel is eager to hear your arguments this morning on the question presented. And at this time, we would entertain the arguments and statements of the petitioner. Counsel Lalou, would you proceed, please?
Thank you, Justice Donald, Chief Justice. Good afternoon. My name is Yasmin Lalou, and I am counsel to Servotronics. I am here to explain that there exists no basis to exclude in a categorical fashion private commercial tribunals from the scope of Section 1782. Before I proceed, I would like to acknowledge how Justice Ginsburg is missed today, not only for her transformative impact in general, but because the topic of Section 1782 is very close to her heart. She delivered the court's opinion in the seminal Intel case, and she did so because as a student and law professor at Columbia, she had worked closely with Professor Hans Smith, the father of Section 1782 as we know it. Now turning to the case before us. The question is, does the discretion granted to district courts in Section 1782 to render assistance in gathering evidence for use in, and I quote, a foreign or international tribunal cover, encompass private commercial arbitral tribunals, as the Fourth and Sixth Circuits have held, or excludes such tribunals without expressing an exclusionary intent, as the Fifth, Second, and in the case below, Seventh Circuits have held. Our argument today is divided into 3 parts. We will establish that the language of the statute includes private commercial tribunals, and there is no basis to exclude it. I will then explain what this is also supported by the legislative history of the statute to show that commercial arbitral tribunals are squarely within the scope of the statute. Finally, we will dispute the various policy reasons invoked against the expansion of the statute to commercial arbitrations as false and misconceived, to show that any concern about any abuse of the statute in certain commercial arbitrations are best served by allowing courts to exercise their discretion under the statute rather than by imposing a wide-ranging and counterproductive categorical limitation on the application of the statute.
Ms. Lalou, in your presentation, I wonder if you would address whether or not there is any ambiguity with respect to the definition of tribunal, and where should we look for the definition in order to determine the breadth and application of that term. So just in the course of your presentation, if you would address that.
Thank you, Chief Justice, and I intended to do so. And if I do not, please let me know. So the plain meaning of tribunal includes commercial tribunals, and I will explain you why. This is probably one of the easiest cases this court will have to decide this term. This and probably another recent one in which we were asked to swift but refused to overturn a presidential election. It is an easy case because under the plain meaning of the statute, private commercial arbitral tribunals are tribunals within the scope of the statute. The statute says the district court of this district in which a person resides or is found may order him to give his testimony or statement to produce a document or other thing for use in a proceeding in a foreign or international tribunal. The plain meaning of the term tribunal is conclusive in the absence of clearly expressed intent to the contrary. As we show in our brief, courts have used the term tribunal to describe private contracted for commercial arbitrations for many years before Congress added the language to Section 1782 in 1964. And closer in time, this court used the term international arbitral tribunal to describe a private arbitration in the case Mitsubishi Motors Corp. In Bear Stearns, the appellant NBC had submitted numerous references to court cases, international treaties, congressional statements, academic writings, and even commentaries of Blackstone and Story to refer to private arbitration bodies at the tribunal. And these sources I submit, Chief Justice, are where the court should look at to find the definition, the meaning, the common meaning of what a tribunal is. And despite this...
So I want to ask you, how does, for example, the European Commission fit within the definition that you have just proffered? Because I think in one of the cases you referenced, the issue was whether or not a person could be compelled to submit, whether the European Commission rather could be compelled to submit, or the party could be compelled to submit to the European Commission. So how does that relate to your definition?
So I think, in short, we would be speaking about a decision-making body who adjudicates evidence. Okay. And in this case, I think in the Intel case, we're talking about the Directorate General of the Commission, not the Commission itself. And that, pursuant to EU regulations, has been delegated the judicial authority to review the facts and adjudicate and enforce competition statutes on behalf of litigants or on behalf of the European Union in the context of disputes. So this is the reason why Intel determined that Section 1782 applied to that very unusual case where the case was pending before a very special type of proceeding. But in essence, it is the decision-making process and fact-finding.
Thank you.
Of course, thank you, Chief Justice. Despite those statements, this evidence statement that had been submitted by NBC, the Second Circuit inexplicably concluded that this only showed that the statute did not unambiguously exclude arbitral tribunals. This approach by the Second Circuit is contrary to the fundamental canon of statutory construction that warns courts against reading exceptions into legislations that are not expressed in the language of the statute. Of course, we agree that dictionary definitions alone do not necessarily produce the conclusion that tribunal extends to the proceeding at issue here. However, courts' long-standing usage of the word shows not only that one permissible meaning of tribunal includes private arbitration, and also that that meaning is the best reading of the word in this context. In addition, the legislative history of Section 1782 lends further support to an inclusive interpretation of the term tribunal to cover private arbitration tribunals. Congress introduced the term tribunal in the 1964 amendment to Section 1782, which replaced the phrase a judicial proceeding pending in a foreign country with one that reflected congressional intent to expand the reach of the statute to a proceeding in a foreign or international tribunal. The Second Circuit in Bear Stearns held that because the Foreign Relations Code applied only to governmental tribunals or those established by a treaty to which the US was a party, the same limitations should be read into Section 1782 as amended in 1964, despite the fact that Congress left them out, although they should have put them in. Observing that this statute used the phrase international tribunal, the NBC Court, the Second Circuit Court, stated in a conclusory fashion that there is no question that the statute applied only to intergovernmental tribunals and that the purpose of the 64 Amendment was to broaden the scope of the repeal statute by extending the reach of the surviving statute to intergovernmental tribunals not involving the United States and not to extend discovery assistance to private arbitration. And this is another violation of fundamental canons of statutory interpretation by the Second Circuit because it violated the fundamental precept which is to enforce clearly expressed legislative intent by Congress. And the legislative intent and the history and the intent of Congress shows there is no support for limitation to governmental tribunals, as those courts say. In this respect,
okay, but you argue that that language shows that there is no limitation. Couldn't the converse be argued equally? That because Congress didn't put a certain language in there, that they did not mean for it to be inclusive? Because if we take your argument, doesn't it kind of show that Congress had in mind matters governing foreign governments rather than any foreign party? Why isn't that a logical reading of the language?
It could be a logical reading of the Congress, except of the Congress intent, my apologies, except that this distinction that the Second Circuit has drawn between governmental and non-governmental arbitral tribunals is a false distinction, which is what I'm going to explain in this tribunal. As a practical matter or legal matter, this distinction does not exist as a matter of law and has been forced by Second Circuit in 1999 into Section 1782 and has repeated itself since then. And you read my mind, Chief Justice, because I was going to say that we will show you in just a few minutes that this distinction between governmental and private commercial tribunals has no legal or practical significance. One other reason, based on legislative history, that the Fifth Circuit used to reject the application of the statute to commercial arbitration is to say that it was so novel, that commercial arbitration was so novel, and I quote, in 64, that the drafters of the statute could not have intended to refer to arbitration tribunals that were not part of government agencies or established by treaty as tribunals in the 64 amendments. But this is just historically false and wrong. Members of Congress were undoubtedly aware in 1964 of the growth of private commercial arbitration. The Federal Arbitration Act had been adopted in 1920. The International the International Chamber of Commerce in Paris and its International Court of Arbitration, one pillar of international commercial arbitration, had been founded in 1923. The New York Convention that had been signed in this country, United States, had been signed here just 6 years before in 58. And Congress was going to implement that New York Convention into the FAA in 1970, just 6 years after Section 1782 was amended. The Sixth Circuit went to great lengths to analyze case law predating the amendment to show that private commercial arbitration was not a novelty in 1964, and concluded that even if it were inclined to permit statements in congressional reports to color our view of a statutory term, it would not rely upon such statements. If
Counsel,
anything,
Ms. Lalou, does your, I'm sorry.
No, go ahead.
Your broad reading of the statute, will it frustrate the ability of arbitrating parties to control the parameters of the arbitration? I'm wondering, will the parties will they be able to contract around a broad reading of this? And if they are you placing an onus on the arbitrating parties to always now draft that into their arbitration agreements?
Absolutely. I think this is a consideration that the parties should and could incorporate into the arbitration agreement. Arbitration is a product of the parties' agreement, and they should be able to determine before the dispute arose or later whether they want Section 1782 to apply. And many parties fearing the application of Section 1782 have put that in their clauses, and some have decided to put the seat of the arbitration in the United States in order to avoid the implication that the tribunal was an international or foreign tribunal, to make sure that such provision was not available. And
Counsel, if I can just interrupt right there, your argument is a bit circular, suggesting that parties can seat the arbitration in the United States in order to avoid 1782 discovery. But of course, that then opens them up to more American-style discovery because they have the assistance of the district courts. So doesn't that undercut your argument that it is more difficult for parties to avoid 1782?
Well, I don't think it does, Justice Strong. I think this proves my point, is that one reason why people have been wanting to exclude commercial arbitration from 1782 is that it should not offer more discovery in that case than under the FAA. But now you're saying it would put the same situation. So I'm not sure this undercuts the logic of the argument.
But as Justice Strong said, if you bring it to the United States, the district courts then would consider applying 1782 applications for arbitration. And wouldn't that really destroy that fundamental benefit of arbitration? Because arbitration is supposed to be, more narrow, more efficient, more cost effective. And in traditional commercial litigation, discovery is one of the biggest drivers of that cost. So don't you undermine that to a degree?
I do not think so, Your Honor. And I think when you're talking about efficiency, and you're anticipating my argument, efficiency as a bar to Section 1782 in arbitration is a wrong reason. Efficiency was and informality is historically the basis why ADR grew in the United States, but this is not true for international commercial arbitration in the United States. Many international arbitrations imply very involved, very complex procedures with bifurcation, with several rounds of briefing, with motion practice, pre-hearing motion practice, and extensive discovery. As such, I do not think that the premise of informality should be a bar to discovery. But this argument completely ignores the fact that this is the whole point of Section 1782, to provide discovery available in U.S. courts, which is unavailable abroad. Courts in the United States routinely grant expensive discovery to be used in a French court, to be used in an Italian court, and they have no concern that this sort of discovery is not available in Italian courts. The foreign litigants probably can be said never to have bargained for that, and yet they grant that discovery.
Counsel, if I could interrupt, I'm sorry, it's Justice Strong again. A couple of concerns about your argument. One is that in international arbitration, discovery may be relatively broad at times because of the complexity of the disputes, but the discovery, and I would call it disclosure, is more of an international nature as opposed to a U.S.-style discovery vehicle. And the second is that international commercial arbitration, if I recall the numbers, has expanded greatly in the 1980s, which is somewhat contrary to your argument that international arbitration in the United States was well known far beyond that, or may I say, well used. But the number of international arbitrations that include American parties, I would suggest, far exceeds the number of matters involving 1782 discoveries in a French court or in other courts. I have not seen a great influx of 1782 applications, except in the area of international arbitration, be it investment or commercial arbitration. Does that undercut your argument?
Well, I don't think so. I think about your first point that disclosure is much more limited in arbitrations. It is irrelevant to the interpretation of a statute that was offered by Congress as a tool to foreign tribunals. As I said again, the proceedings before a French court do not have any form of disclosure, not even anything remotely available under international arbitration, and yet courts give that discovery in support of foreign tribunals. So that reason does not work and goes against the whole purpose of Section 1782. As to the other point, I'm not sure I understood the question, Justice Strong, and I'm going to ask you to repeat it. My apologies.
No, it's because I was trying to sneak in two questions when I conflicted with Judge Wang. I had a historical argument in place, so my apologies. I was merely saying that the sheer numbers of international arbitration involving U.S. parties expanded in the 1980s and 1990s. So your argument going back to the ICC being founded in 1920 something, the signature of the opening of the New York Convention 58 and the U.S. extension somewhat later seemed to me to be a somewhat specious argument in that there were not many, as a factual matter, there were not many international commercial arbitrations involving U.S. parties, or certainly involving the possibility that 1782 could be invoked at the time of the NBC case, and certainly the time of the passage of the statute.
Well, I'm not sure statistical data supports it as a matter of international,
I've actually done it.
of foreign seated arbitrations. But here we are talking about whether the form of dispute resolution existed and was known to Congress. I posit it did in 1964, and commercial arbitration as a form of means to facilitate commercial disputes, commercial trade, has not started after the 60s. It started at the beginning of the 20th century. Of course, it grew after the ancestor of the WTO, etc., came up. But that doesn't certainly mean that private commercial arbitrations did not pre-exist the 64 amendments.
Counsel, I'm gonna ask you to wrap up in 30 seconds, and you'll have your full rebuttal.
Thank you, Chief Justice. I think through your questions, and I'm very thankful the court enabled me to cover most of my arguments. I will just go back to the fundamental point about the informality of arbitration and whether this should justify a categorical exclusion of Section 1782 by saying, instead of making a broad-ranging rule that Section 1782 should not apply to commercial arbitration, even though courts say it should apply to investor-state arbitration, and I will show later that this distinction is false. We should instead ask tribunals to weigh in whether they are interested in the discovery that is being sought before a U.S. court. A U.S. court should ask an applicant to show how the tribunal will react to that, whether they will admit the evidence, whether the schedule of the arbitration is even compatible with the schedule of U.S. litigation.
And we thank you for your argument. We will have your rebuttal. At this time, Mr. Alexander Rosen, we will hear your argument as the respondent. And if you will come off of mute, please.
Thank you, Chief Justice. My name is Alex Blumrosen, and I am here to present the other side of the story. We've discussed the language of the statute and a little bit of the legislative history, so I'll say just two words about this. The plain meaning of the terms used in Section 1782 are not so plain, and indeed the Bear Stearns Second Circuit opinion shows that they are indeed ambiguous. And so the use of the plain meaning rule of construction simply will not get us anywhere. The word tribunal can include private arbitration, but it could also exclude them. And there's nothing in the term itself that says that it's included or excluded. And given that dearth of information that comes from the simple words on a page, we need to look somewhere else. So where is that somewhere else? It could be the legislative history. We've mentioned Hans Smit, Professor Smit from Columbia, and Professor Smit was instrumental in the drafting of Section 1782. And after 1782 was adopted in 65, and then in the 1990s, he enthusiastically explained and exclaimed that 1782 included private commercial arbitrations. But that was not the case at the time of 1964 when the reform was made. The terms submitted to the Congress in explaining why 1782 was needed and necessary talked about intergovernmental tribunals. The history of 1782 up until that time concerned exclusively intergovernmental tribunals or governmental tribunals, and not at all private arbitration. And what the Second Circuit in Bear Stearns found it incredible, and I agree, that that Congress would have expanded 1782 to include private commercial arbitrations without even mentioning the intent or their intent to make that expansion as they were considering it. Nowhere is there that legislative intent. And as you mentioned earlier in your questioning, it is telling that as far as legislative history goes, that the New York Convention was not adopted until well after 1782 was adopted. The New York Convention was ratified by the United States in 1970. As Justice Strong mentioned, the significant growth of international commercial arbitration that called on 1782 really started in the 90s and going forward. And so this is an issue that Congress did not even consider in 1964. So we need to look at something else. And since we are here in the Supreme Court of the United States, we are not bound, or you are not bound by decisions of other courts. We should consider some of the policy ramifications, and that's what I would like to address.
Mr. Blumrose, before you get into the policy ramifications, isn't it the possible argument that in light of the variety of foreign proceedings that are now and were then resistant to classification in domestic terms, that Congress simply left unbounded by categorical rules the determination of whether a matter is proceeding in a foreign or international tribunal? I mean, isn't it possible that the language included was deliberately left fairly broad to encompass an evolving body of proceedings, and leaving it to the courts to further cabin that and apply some functional approach? Is that a possibility?
Well, it's a possibility if Congress had even considered it. So the initial evidence that we have is that the Congress did not even consider whether private commercial arbitration should be included. Now, as to whether they intended also to have a general term that could later be cabined by the courts, that also is not in any of the legislative history. The legislative history doesn't say we're going to start with a general term and we'll see how things play out. Now, in
Mr. Blumrosen,
yes.
The legislative history that you're referring to talks about tribunal not being confined to conventional courts, but extending to administrative and quasi-judicial proceedings. Are you suggesting that we read into this legislative history that Congress meant to only those administrative and quasi-judicial proceedings that are state-sponsored?
Yes, I am. That was the history of 1782 before 1964. The words used in 1782 were modified, but the reference back to international tribunals and government tribunals it appears in the legislative history, and there is no indication that from that history that there was an intended expansion of the scope of 1782 to include private commercial arbitration.
I guess I'm just not sure what grounding we have to read this exception into the statute. Why should we understand, for instance, state-sponsored arbitration to be covered by the statute, but not private commercial arbitration?
Well, it's thank you, Justice. It's not really an exception. Expanding the scope of 1782 to include a series of or a type of dispute that was not considered by Congress at the time, that was not intended by Congress to benefit from this this procedure. That I think that is the real error. That would be a mistake. That would be an overstepping of the powers of the courts, because after all, we're in a statutory construction question. We're here to figure out what Congress wanted, what they intended, what we can glean from the history of the debates, and to expand the purpose and the scope of 1782 to a series, to these procedures that were not envisaged by Congress would be a bridge too far.
The problem is we don't know what Congress intended at the time because we have so little information to go from. All we know is that they wanted a fairly expansive broadening of the statute. They changed the wording from any judicial proceeding pending in any court in a foreign country to a proceeding in a foreign or international tribunal. And I'm not sure that we have a principled reason for cabining that expansion to state-sponsored proceedings.
Mm. Well, I think that we need to look at some of the policy ramifications, because I think that the policies behind 1782 can help this court cabin and define exactly the scope that was intended by Congress, because the policies, the impact, the effect of 1782 in real life, in practice, and now we have 50 years of practice, is very telling. There have been a number of negative policy impacts that this court can address, and have 1782. I want to say go back to, but have 1782 be the statute that Congress had intended. The first policy issue is that 1782, the way it's drafted now, creates an uneven playing field for U.S. litigants. U.S. litigants are the only litigants, U.S. parties are the only litigants in the world who are in a country that allows this type of very broad discovery. And as a consequence, when they are brought to US courts, they are subject to providing discovery to foreign tribunals when their counterparts, their adversaries in the foreign countries, where the foreign adversaries' documents and data and witnesses are located, are immune to that kind of discovery. And this creates...
Doesn't Intel tell us that the foreign judge or the foreign arbitrator is the one who can require reciprocal discovery? Why shouldn't we leave that to the foreign commercial arbitrator to say, we're allowing one side to benefit from US discovery, and so the other side should also be agreeing to reciprocal discovery?
Well, I'm not sure the legislative or the basis for requiring an adversary located abroad to produce documents located abroad. I'm not sure that that even exists. I'm speaking to you from Paris, France. If a tribunal here in France required a a French party to produce witnesses and documents to the same extent as American discovery is allowed in the U.S. court, it simply wouldn't work. The tribunal probably wouldn't allow it, and certainly the courts, for foreign public policy reasons, would stop that kind of, or could intervene to stop that kind of forced discovery abroad according to American terms, because they're simply not in the United States. And so another policy consideration that I'd like the court to consider is that the 1782 gives much more power to the litigants abroad to seek discovery in the United States than equivalent American litigants in an American arbitration would have under the FAA. So if you are a party in an arbitration in the United States, you can't, as a litigant, simply go to court and get discovery. That doesn't exist. You have, under the FAA, Article 7, you need to go to your tribunal, your panel, and the panel can make discovery requests. And even then, there's some debate about what kind of discovery is available. There's a debate, there are certain cases out there that say that pre-hearing witness depositions and pre-hearing document discovery are simply not permitted under the FAA, even if the request comes from the tribunal. Whereas in 1782, yes, Justice?
Yeah, sorry. This is Justice Strong, and I apologize for interrupting you, but you're starting to move away from the point that I was going to ask you about. You had said litigants, and I apologize. I don't have access to 1782 text right in front of me because I'm unfortunately on my phone. But isn't the language actually interested parties? And don't we have a concern in arbitration about the privacy and confidentiality of arbitration, making allowing parties and litigants to hide improper behavior? So if we do allow any interested party to obtain U.S.-style discovery in an arbitral proceeding, isn't that furthering the policy interest of obtaining full airing of the facts and allowing people to understand what is happening in a quasi-judicial proceeding?
Well, I'm not sure which way that cuts, Your Honor. It's certain that when you mention confidentiality, that the parties who have recourse to arbitration often do so for confidentiality reasons and confidentiality purposes. And that doesn't mean that they are hiding something. Confidentiality can be there to ensure the protection of trade secrets and industrial secrets that simply should not be disclosed in a public courtroom. And by bringing 1782 into the arbitration world, in fact, you are limiting the confidentiality expectation that arbitration litigants bring to the table. That is part of the arbitration agreement that they made.
Thank you.
And so expanding 1782 to include private commercial arbitration would also be inconsistent with the United States' longstanding policy in favor of arbitration. If one looks at your own jurisprudence, looking back over the years, whether it's Shearson, Mitsubishi, Shine, more recently, there is this policy favoring arbitration. And what does that mean? Arbitration is when the parties, further to their agreement, have entrusted the resolution of their dispute to private arbitrators sitting on a panel. By introducing 1782, and making available a court procedure for the parties to get discovery outside of the panel context, for the litigants to go to a court without the authorization or permission or approval or even information of the arbitration panel, is an intrusion on the arbitration process, an intrusion on the parties' expectations about how arbitration would work. And as was mentioned earlier, discovery may have very many benefits, but it's expensive. It's very costly. And I'm not sure that Congress intended to impose that kind of cost and delay on the parties in an arbitration when those
Counsel,
parties. Yes, Justice?
Can the Intel discretionary factors take care of what you are concerned about right now? I mean, one thing you're saying is that parties can come to the US and ask for discovery, and the arbitral panel may not be on board with that. But the Intel factors go directly to that point. It asks whether the foreign tribunal is receptive to US judicial assistance, and whether the parties are actually trying to circumvent the foreign tribunal's proof-gathering restrictions. So can't we just, doesn't it make more sense, instead of going with a full-on blanket exclusion of foreign commercial tribunals, to simply rely on the discretionary factors that are already set up in Intel?
Well, thank you, Justice. But you've just confirmed by the very question that the courts would then, applying their discretionary factors under Intel, be substituting their own analysis, their own review, and their own conclusions for those of the arbitrators. And it's the parties who had decided to go to arbitration to have the arbitrators decide, not to have a court decide.
Well, we have seen cases in the lower courts where the foreign arbitration tribunal weighs in with their preferences, or for instance, other tribunals as well. In Intel, the European Commission weighed in with their preference.
Yes, and you're absolutely right, Justice Wine. But if I recall correctly, the Commission did not want to participate in the 1782 process and was dead set against it. And yet, the courts really did not take that into account. So there's nothing in the legislative history that refers us to the four Intel factors. These were a judicial creation, and they were a creation that, in my view, has compounded the problem because it doesn't address the fact that this decision-making should be at the level of the arbitration tribunal and not at the level of the courts. I think
Thank you, Mr. Blumrosen.
I believe, Justice Donald, that my time is up.
How much time does he have remaining, if any?
Mr. Blumrosen's time is up.
Okay. Well, thank you very much for being mindful. Ms. Alaulu, you have 5 minutes for rebuttal.
Thank you, Chief Justice. I would like to go to one of the leading and significant argument of my opponent, Mr. Bloom-Rosen, which has to do with the distinction between commercial tribunals and governmental tribunals. Well, if you agree that treaty-based arbitration, bilateral investment treaty-based arbitration should fit within Section 1782, then there is no basis to exclude commercial arbitration. This is a distinction that was made up by the Second Circuit and that was forced into the statute, and that has since taken a life of its own. Following the question by Chief Justice Donald earlier, what's a tribunal? Well, tribunal is a tribunal is a tribunal is a tribunal. Where you have your point exactly as Mr. Bloom-Rosen said in arbitration. You appoint private individuals to resolve a dispute between the parties and make it in a final manner. This is true in investor-state arbitration, in treaty-based arbitration, or in commercial arbitration. The distinction also between government-based, treaty-based arbitration and commercial arbitration is inexistent under US law. The FAA does not distinguish that and between an ad hoc arbitration under BIT or any other ad hoc tribunal under a contract-based arbitration involving the state. But
Ms. Lalou, suppose we agree with you that a broad reading of the statute is appropriate here. It sounds like you're suggesting that the court should use its own discretion to determine when we should be granting this discovery to foreign commercial within commercial arbitrations and when we shouldn't. Can you say a little more about how courts should be making that decision?
Well, I'm sorry, it's a bit too apropos, but this I want to cite you. I want to cite your article, Justice Wang, that you published in the Chicago Law Review called "Exporting American Discovery," and I'm going to quote you: "Implementing Intel's discovery factors requires more active judicial management of foreign discovery requests by federal courts and more active participation from foreign tribunals. Federal judges can accomplish this by systematically providing written notice to foreign tribunals, which includes arbitrations, when Section 72 requests are received and sua sponte, seeking the tribunal's input. District courts may specifically ask foreign tribunals to weigh in on the Intel factors to provide information needed to apply the federal rules proportionality analysis or to share scheduling information so that US discovery can be produced in time for it to be taken into consideration abroad." So as a practical matter, there is no limitation, and there should be no limitation to the court's discretion to avoid applying 1782 when it should not apply. And this is and I'm going to finish later the point about commercial and investor state, but on this point specifically, many complain about potential excesses of using Section 1782 in private arbitrations, because obviously parties use 1782 to have a technical advantage. They often abuse that, but that is true when it relates to litigation or arbitration. And Mr. Bloom-Rosen talks about the expensive discovery available under Section 1782. Absolutely, that is true, but that is a result of Section 1782, not of whether it should be applied to commercial arbitration or other arbitrations. One quick point about this false distinction, and I will conclude with that, between treaty-based arbitration involving state and contract-based arbitrations involving states. And as I was saying, that has no basis in law under the FAA. The New York Convention does not recognize that distinction. Yes, there is the ICSID system, but that is a system on its own, which is based on the ICSID Convention. But all these tribunals in commercial cases or investor state cases derive their authority from the agreement of the parties, one of which happens to be a government or state-owned entity. And I would like to refer you to Judge Brower's article on what he called investor-commercial arbitrations, and I will conclude with that. Much of the existing relationship on international arbitration tends to emphasize the distinction between contract-based commercial arbitration and treaty-based investment arbitration.
Ms. Lalu, you may finish your sentence, but then your time is up. Just finish your sentence.
Yeah, what his point is that he discusses that the developments in the fields of commercial and treaty-based arbitration to argue that the real distinction today is not between commercial and treaty-based arbitration, but between mixed investor-state arbitration, including both contractual and treaty mechanism on the one hand, and purely private commercial arbitration on the other.
Ms. Lalu, we thank you for your rebuttal. Mr. Blumrosen, you may now have your rebuttal.
Yes, thank you, Chief Justice. My esteemed colleague and adversary, Ms. Lalu, earlier was talking about the fact that under 1782, American parties are at a disadvantage because they're subject to this extra burden. That this is similar to when foreign parties, if I understood correctly, are in American litigation, in court litigation, and they are themselves exposed to the burdens of American litigation that they may not have expected. The difference being that if the foreign parties are in a U.S. court, there must be jurisdiction. So either they accepted the jurisdiction of the U.S. courts, or they have minimum contacts with the United States sufficient to bring them into the U.S. courts. And so they
my understanding of Ms. Lalu's point was to compare a foreign commercial arbitration with a foreign judicial proceeding, for instance, in France, where the parties have not been subject to U.S. jurisdiction and also would not be entitled to U.S. discovery. 1782 allows U.S. discovery in a French court where they wouldn't otherwise get it, but somehow you're saying that it shouldn't be allowed in a foreign arbitral commercial tribunal where they also wouldn't be able to get it.
Well, the parties would be entitled to come to the United States to get discovery for the French court proceeding, but that discovery would only be against the U.S. party. And not against the French party.
And that goes back to the point raised earlier. Well, if that's the position, doesn't that give the parties unequal and in some cases unfair either benefits or impose unfair burdens because you're going to have a lack of equal access to information?
Well, I think that is a very serious concern, Justice Donald. And so in the case that I was just explaining, where we're in a U.S. court system, there are minimum contacts and the parties are in the U.S. courts for a reason, that is the minimum contacts at the very least. But in arbitration, it is completely different because arbitration is a creature of the parties' agreement. And if we, as Justice Donald just said, if we start imposing requirements and burdens on that arbitral system that were not anticipated by the parties, that are not part of the parties' agreement, then we are defeating those party expectations, and we are burdening not just the U.S. party, but we are burdening an entire ADR system that is working very well, where there is speed, there is efficiency. Ms. Lalu is absolutely correct that there is a lot of discovery available in international arbitration. There has been more and more, but under the IBA rules of discovery, under other institutional rules, the discovery available is always more circumscribed and limited in arbitration than it is in U.S. courts. And so this intrusion of U.S. court discovery into the arbitration process would create a very real and serious burden on the arbitration process, not just on the parties, but on the process itself.
Thank you very much. This concludes the argument. Ms. Lalu, Mr. Blumrosen, The court thanks each of you for your arguments. The matter is submitted, and we will give you a ruling within the term. This concludes the hearing on this important question, and we will rule.